Yes, good afternoon, everybody. And it's wonderful to have you all once again on this cCep platform in large numbers today. Thank you so much. Um, as far as today's subject is concerned, it's extremely interesting. It's about intersection of the private international law and and the taxation issues for a long period of time. In fact, I remember my days in 1977 when I was doing my master's in law. At that point of time, we had this issues, of the private international law, public international law, and so on and so forth. But tax matters were largely pure domestic. And then, as you all know, came one of the major rulings in 80s, Visakhapatnam Port Trust, which really highlighted the importance of public international law. Okay. Now, as you all know, public international law really governs the relationship between the two sovereign states or international institutions. Um, you know, so actually, the concept of sovereignty, as we all know, allows countries or the states to determine what they want to do in respect of their law. But when different sovereignties come together to do cross border work, typically there is a little bit of a disconnect or conflict or what you call, some difference. And at that point of time, both countries, if they want to and if they're friendly relation or otherwise, they would try to resolve the issues either through a text kind of a treaty, or sometimes there is a customary law, what's the customs, there's no written statement about it, and give up some degree of their sovereignty in favor of other country so that the conflicts are avoided. So primarily public international law relates to the relationship between the two sovereign states or international institutions like United Nations and other ones. But for a long period of time, not much issue arose or came to the court in relation to private international law. The private international law drives relationship or administration of law in relation to private entities. And it means, for example, if a company is incorporated in accordance with Delaware law, in accordance with Mauritius law or otherwise. Now, if it behaves or it complies with those laws, then maybe India would not say that, okay, you should have done in accordance with our law. If it's liquidation according to that procedure, if it is merger in the US, two companies merging, it will be the US law. And India will recognize that, although Indian law may be somewhat different. So in the process, what happens is that the private entities, are basically driven by what is called private international law. Actually, in the legal language, it's called conflict of law resolution. So, the interaction of private international law was not much, discussed, debated, except about 8, 10 years ago in the case of Nicholas Applegate. Also, we raised this issue, and it from time to time it has been discussed. But the most important development that has happened is with this Aberdeen judgment, and it's very interesting how Indian courts have looked at the private international law, particularly in the context of the private entity such as Aberdeen, and especially in the matters of funds, practice. We come across a lot of these issues because fund is such an interesting space where you deal with number of different types of entities, number of different jurisdictions, number of different issues that come up. So for resolution, you have to apply the principles of private international law. Of course, as far as public international law is generally only international law. When you say international, it generally means public, and that is a treaty law with which I think many of you are now familiar. A lot has happened, everybody's discussed, but it is very important that how the principles of private international law apply. And as I said, that regulates the private entities. For example, even domicile, and in Succession Act also it's applied. If, for example, a French national leaves, say, movable property in India, car or whatever it is, and something happens to him, he dies, and then which law of succession will drive, right? And it is the uh, law of domicile, which is France. So his succession will be driven according to the French law. As I said, as far as foreign companies are concerned, like in case of Recharacterize, you know, the Mauritius protected cell companies were used, and whether the losses can be set off against the one cell or the other, and all whether it's one entity or separate entity, and stuff like that were the questions involved. And you know, so it is the law of that country that will be respected by the Indian courts, and those are the principles that are really very, very interesting. And so far, not much discussion had happened, and I'm very happy that Rajesh, Shipra, Anandu, and all those them really worked a lot on this particular Aberdeen matter, and because to explain the principles of international taxation with the private international law are very, very complex at point of time. And we had Poros Kaka, very able counsel, to argue also. So it's very interesting to work on this and to understand this concept. I'm sure these principles, which you will perhaps have some feel of it today and learn about it, you will really, be able to use them in in your day-to-day life, and I hope it would be very, very useful. Uh, with those words, I would at this point in time stop and request Rajesh, who led the whole initiative, and to talk to you. So he will give you some glimpse, and then other colleagues will take it forward. Most welcome. If you have any questions, please keep on, you know, writing them, and we'll try to deal with them as much as possible. But most welcome. I'm delighted, and thank you for coming on board in so many large numbers. And let's do some more interesting, exciting things together. Thank you. So, Rajesh, over to you.
Thanks, Nishith. And again, as Nishith rightly pointed out, this is actually a very fascinating area as to trying to see what is the intersection between private international law and international tax. Most tax practitioners today, when we look at it, we look at the Income Tax Act, we look at the double taxation avoidance agreements, but we don't generally go beyond that. But there are a lot of matters. A simple example would be that how would I treat a Delaware LLC for Indian tax purposes? Would I look at it as a company, or would I give a differential treatment? Similarly, a foreign trust, how would I treat it for Indian purposes? Right? So for all of these questions, the answer is not necessarily found in the Income Tax Act, or I don't necessarily have to go in onto the treaty, but I have a broader aspect, which is where the private international law angle comes into place. Similarly, issues relating to even simple issues such as summons, such as enforcement, all of those, while tax treaties do cover a certain ambit of it, but not everything is only covered within the treaties. You have to look at law much beyond that, which is where private international law comes into place. And as Nishith pointed out, I think the Aberdeen judgment is probably the first reflection in terms of how courts have in tax matters looked at the role of private international law in international tax matters. So I think, considering the time element that is involved, I think the way that we would sort of go around this particular session is to sort of set out some of the basics around private international law, what kind of principles actually come into place, look at what is the intersection between private international law principles and tax treaties before delving a little bit into how some of the cases have looked at it. And also on a practical level, try to see how do you then, what are the facets in the tax law which have an element of private international law, or where you will have to look at private international law also as sources which you will have to rely upon while coming into any kind of judgment or position. So with that, let me just take it over to Anandu to sort of set out at least the basic areas of private international law which do have a element when it comes to international tax. So Anandu, why don't I just take it out to you on that?
Thank you, Rajesh. I think Nishith did put it across very well. The easiest way to understand private international law is by looking at what international law is. And typically when we talk about international law, we understand it as public international law, the law that governs the relationship between nation states, state bodies in the international arena. Private international law, on the other hand, conflict of laws is another word that's used to define this area. It's really just a set of rules that seek to help a court in deciding cases that have foreign elements to it. The reason these rules are important are because in cross-border situations where parties are not always subject to the same system of law, more than one court or more than one country, courts of one country can have a claim to rightfully deciding a case. Your classic example is, say, a sale of goods between a seller in one country, a buyer in another country. The goods are supposed to be delivered in a third country. And if a dispute arises between the buyer and the seller, you could have questions on where is the dispute supposed to be brought, what law is supposed to be applied to the dispute, is the court hearing the case required to recognize and implement foreign systems of law, foreign cases. Those are usually the questions that private international law looks to address. In that sense, it's in the private sphere, transactions between private entities in their private capacity. So what that means is that private international law doesn't really cover sovereign actions, state actions, which is usually left to the ambit of regular international law instead. And private international law really, therefore, is just those rules that help the court decide the case in situations like this. Of course, when I say rules, it's easy to think these rules arise from statute, but it's quite uncommon that there are, at least in common law countries, it's very uncommon for there to be statutes codifying private international law. Most of the rules that we refer to actually came from Dicey and Morris writing a book of rules, which then sort of became a self-fulfilling prophecy where courts started referring to the rules that Dicey and Morris wrote down and said, these are the rules of private international law. So broadly, I think what PIL seeks to address are three things: jurisdiction, which is the competence of a court to hear a case with foreign elements. A court could find that it is not the convenient forum or the appropriate forum and ask that the case be brought somewhere else. The second broad area is the choice of law. Now, in commercial cases, we usually refer to this as the proper law, of whether that's of contract or of tort, which the court, if the court finds that it has jurisdiction, it has to determine the choice of law that it applies. And the last sort of broad area that PIL addresses is the recognition and enforcement of judgments, whether that's judicial or arbitral awards. The New York Convention on Enforcement of Arbitral Awards is a very common example of a private law convention, and a rare example, I should add, because these conventions are in common. The idea of these conventions is to set out some general rules for systems and courts to follow in deciding these cases with foreign elements. And as I said before, PIL rules are usually limited to the private sphere, and they do not address constitutional law, criminal law, administrative cases, because the idea is that public law cases are more appropriately left to the states to decide themselves. It flows from the it flows from the principle of respect for each state's sovereignty. So state A will respect the public laws of state B and will not seek to sit in judgment over state B's implementation of those laws. So broadly, that's what private international law looks to address. I quickly want to touch upon a couple of cases that illustrate how the law works. Before I think we move specifically to how private international law rules interplay with tax. The first case I'm discussing is an Indian case from the Supreme Court. It's a case called TechNip versus SMS Holdings from 2005, which had an interesting fact pattern. TechNip, a French company, bought a minority shareholding of cCep, which is another French company, in April of 2000. And subsequently, in October of 2001, it raised its shareholding to 98%. Now, the key factor here is cCep at all times ultimately controlled a listed company in India called the Southeast Asian Marine Engineering Company Limited, CMAC. The question before the court in that case was, when was the acquisition completed? When was the requirements of the takeover code in India triggered? The reason this came to the Supreme Court was because there was a difference in open offer requirements under French law and under Indian law. So depending on whether depending on where the takeover could be said to have been completed, the court was required to analyze if any SEBI laws had been violated. Now, before the Indian Supreme Court, it was argued that it was, since the transaction was ultimately one of an acquisition of an Indian company, it's the Indian law definition of takeover, of open offer, that needed to be looked at. Which means, we know that if 25% of the shareholding is crossed, an open offer needs to be made to the shareholders. So it was argued before the court by one set of parties that April 2000 was the relevant date when 29% of shareholding in the second French company was acquired, and that's when the open offer requirements were triggered. On the other hand, the other set of parties argued that this is an entirely offshore transaction. It's one French company acquiring the shares of another French company. The acquisition indirectly of the Indian company is only an incidental matter, and therefore should not be given effect to. And it's the French law that should apply. Interestingly, the Supreme Court looked at the private international law principles governing status, which depend on where the companies were incorporated. The court noted that these are both French companies set up under French law, and their actions could only be in accordance with the law that allowed them to be incorporated and allowed them to act, which in this case was French law. Since the relationship between one French company and another French company is a question of French law, it is the French law requirement that should apply. And therefore, it was not the Indian takeover code's requirements that apply. And so this was like a landmark judgment in 2005, because for the first time, the Supreme Court acknowledged that questions relating to the status of an entity, in this case, a legal person, had to be decided according to the law of its domicile, which in this case was France. One of the cases that was cited in TechNip, which is the second case that I'll be addressing, is a case called the National Bank of Greece versus Metlis. The reason this case was cited was in support of the proposition that, yes, it might be one French company acquiring a second French company, but since the underlying transaction is an Indian transaction and the rights and obligations flow from Indian law, it is the Indian law that should be applied. So it's interesting to see how TechNip can be contrasted with the National Bank of Greece. In that case, what had happened was that a Greek bank had issued certain mortgage bonds to bondholders in the UK in pound sterling. Those bonds were guaranteed by a second Greek bank in Greece. The bonds were subject to English law. Sometime after the bonds were issued, the Greek government passed a law where the second bank, which was the guaranteeing bank, was merged with the third Greek bank, and the successor bank took over all the liabilities, which included this guarantee of the predecessor bank. Some point later in time, when interest payments on the bonds were suspended because of a moratorium that the Greek government implemented, a bondholder sued in England seeking to enforce the guarantee. And really the question before the court was whether can the successor bank, which succeeded to the guarantee, be compelled to make payment of the bond. Now, before the Court of Appeal, it was argued that the successor bank argued that, look, I'm a Greek company. I'm governed by Greek law. There is a Greek moratorium in place which says that I cannot make any payments on the bond. Therefore, I should be discharged. But the English court took a different line of thought. They said, look, this you may very well be a Greek company, and we certainly recognize that your status flows from Greek law. Greek law can create and dissolve companies, but the bond in question is subject to English law. And to that extent, the debt, the obligation to repay it, the quantum, the date of payment are all governed by English law, and this is an English debt. And since the obligation arises from English law would not recognize a Greek provision trying to suspend payment on the bond. And on that basis, it was said that, yes, even though we respect your Greek status, we will not allow that to supersede the English law obligation. So it's a good example of how, even though there are certain questions that private international law allows to be decided in accordance to the law of the domicile, questions relating to rights and obligations, powers and duties are usually decided with reference to the laws of the forum. And we will see this in play later on when we come to Aberdeen. But before we jump to that, I think it will be useful to come to the principles on private international law and how they interplay with tax law. And I'm going to quickly hand this over to Shipra to see how that interplay works in practice. Shipra, over to you.
Thanks, Anandu. So I think we'll stick to two important private international law principles, which I would say are most relevant to taxation matters, especially cross-border transactions. The first one, I think Anandu has sort of already explained while he was discussing the two cases, Bank of Greece and Techne, and that is the principle of lex domicili. This is also the principle which, of course, has been discussed extensively in the Aberdeen judgment. So essentially, as per this principle, the question as to the status, which includes the creation, dissolution, the powers, liabilities, etc., of a legal person, including corporations and individuals, should be decided as per its law of domicile. So essentially, this would mean that even matters such as amalgamation of corporations, which result in a new corporation, conversion of one entity to another, or succession of a new corporation and how does it derive its rights and things like that, are also matters that need to be decided as per the law of incorporation. We'll of course delve into this in more detail once we discuss the Aberdeen judgment and how it interplays with tax questions. Moving on to the second rule of private international law, that is the revenue rule. So essentially what the revenue rule says is that courts of one country will not enforce directly or indirectly the tax laws of another country, and neither will such courts act as tax collectors for foreign governments and public authorities. So just to sort of discuss where does this principle really emanate from. So there was a House of Lords decision in Government of India versus Taylor, where essentially there was a UK company which was engaged in providing certain electricity supply services in India. This sort of undertaking of that UK company was later sold to the Government of India, and essentially there was a capital gains liability arising for the UK company in respect of this sale. After the sale was undertaken, the UK company went into liquidation. So the matter before the House of Lords was whether the claim made by the Indian government to claim that the capital to claim and sort of enforce its tax laws in a UK court, whether that can be upheld or not. So the House of Lords categorically held that since this is a foreign revenue claim, it will be unenforceable in English courts. So this is as far as the basic principle of revenue rule is concerned. Having said that, this principle has sort of diluted over the years. For example, upholding a contractual indemnity for the payment of taxes would as such not constitute indirect enforcement of a foreign tax claim. So the House of Lords has sort of made this exception. Another, I think, interesting question that comes up is how is the revenue rule to be interpreted when it comes to international tax treaties, and whether one can say that by virtue of certain provisions in international tax treaties, this rule is circumvented. There have been a couple of judgments on this issue, which I will delve into. So in one case, which was decided by the Court of Appeals in UK, the UK and South African tax authorities argued that where the UK-South Africa tax treaty provides for assistance in collection of taxes, does the fact that such an article exists in the tax treaty, does it mean that it abrogates the revenue rule? So on this specific question, the court held that no, the revenue rule would still hold good, and direct enforcement of a foreign tax claim will still not be allowed. Having said that, the court did rule that under Article 25A, it's absolutely okay for the UK tax authorities to provide assistance in collection of taxes to the South African tax authorities. So there was somewhat of a dilution of the revenue rule. And I think another matter which is again a UK matter but also relevant to this discussion is where evidence was requested by a Norwegian tax tribunal, and an application was made to summon two bankers to give evidence in relation to certain Norwegian tax proceedings. Now the House of Lords ruled that such a request as such would not amount to enforcement directly or indirectly of Norwegian revenue laws. But what it means is that the Norwegian authorities are just seeking the assistance of an English court to obtain evidence to enable enforcement of Norwegian laws in Norway. So I think this is the way over the years the revenue rule has sort of been diluted, especially considering the developments in international tax agreements. And currently, there are several information sharing agreements between countries. There is an automatic exchange of information that now happens between countries. So when all this is happening, it wouldn't be wrong to say that the revenue rule has been diluted to a certain extent. Since we are on the topic of the interplay of tax treaties and private international law, I think another question that comes up is how would you look at instances where there could potentially be a conflict between PIL and, say, the treaty? So this could be questions of, say, fiscal domicile, questions of, how to interpret undefined terms and things like that. So views on how to sort of look at the interplay of tax treaties with private international law principles. Rajesh, I'd like to get your views on this topic.
Thanks, Shipra. I think when we think about any assessment proceedings in India, right, we have different stages to it, starting with the fact that there are notices or summons which are issued in the first place. Then you have the assessment procedure, and then you have the enforcement related aspects. So I'll dwell on a couple of different aspects. Today, even a simple thing that when you're talking about issuance of summons, under the Income Tax Act, you have certain provisions which relate to the power of the tax authorities for issuances of summons. Over a period of time, you can even have e-notices and other things which are being sent out. But I think one of the questions which sort of arises is that is all well and good when you're talking about domestic persons. But when it comes to international law or when it comes to cross-border transactions, how do you look at a simple thing like issuance of summons? Yes, we do have a treaty in place for that, which is the Hague Convention on summons, for which there are a number of signatories which are there, and which does allow for certain circumstances where authorities in one country or the courts in one country can directly issue summons to persons in another country. But even that is subject to a number of exceptions. And also where countries are not signatory to the Hague Convention on Summons, then the question comes in saying that if under the Income Tax Act or under the GST law, for example, can an Indian tax authority directly send summons? The answer to that is no. You are actually limited in terms of your ability to actually issue summons. There are certain procedures which have to be followed before even a simple thing like issuance of summons can be issued. And this all sort of flows back into the revenue rule, which, as Shipra pointed out, although there has been a dilution, it is not entirely out of the way. Similarly, in respect of matters of enforcement, yes, when you have a treaty in place, well and good, because that does provide for the mutual assistance in respect of enforcement. Where obviously, as Shipra rightly pointed out, it is not a situation where the Indian tax authorities can directly proceed against a person outside of India, but the Indian tax authorities have to go through the tax authorities in the other country, and even for them to actually undertake enforcement, there is actually a court process which is linked to that, and even that can be challenged on multiple grounds, including public policy in most countries. So that's the other important aspect to sort of keep in mind in terms of even when you're thinking about tax law and private international law. The other aspect, which is on the lex domicile, which as we sort of get into, which talks about that a country has to give effect that if a company is incorporated in another jurisdiction, you have to sort of give effect to the laws of that country. And it is very interesting that you have to sort of distinguish this from probably the tax treaties, because a simple thing that today, if you look at the tax treaties, you have the Article 3, paragraph 2, which talks about the fact that terms and terms which are not defined in the treaty, you look at the domestic law of the country which is actually relying upon or enforcing the provisions of the treaty. And that's something similar to what happened in HMRC versus Fowler, where the House of Lords sort of said that, okay, for definition of particular terms, we look at the domestic law. And of course, even in the domestic law, they went into the fact that I will not necessarily give effect to the deeming fiction. So that's the general approach which has been followed. But that is not always going to be the case in every situation, that merely because a term is not defined that you only look at the domestic law, because there are aspects where conflict of laws comes into effect, and where domestic law has to actually then look at the conflict of laws to look at the law in the other jurisdiction. And that would come in where a simple example would be that when we talk about residence of a person, and it talks about residence of a person will be determined basis incorporation, basis domicile, and a few other factors. So for all of that, you're actually looking at foreign law to see how does foreign law actually treat it. So which is why that even when we are looking at tax treaties, it is not an absolute rule, at least that's the way I would see it, that I would always look at only the domestic law, even in respect of terms which are not defined. But there is an aspect of private international law that is there in place. And you will, in certain circumstances, especially when it comes to lex domicili or lex incorporationis, that you have to look at the law in the country of incorporation. And I think that sort of goes into probably a good starting point in terms of just looking at the Aberdeen case, and very specifically how the whether it was the AAR or the courts actually looked at the principle of private international law on the issue of lex domicilis. So, Anandu, why don't I start with you, sort of to run through the facts in Aberdeen, because even that sort of has multiple different nuances and it's very interesting. And then we can dovetail into how the sort of courts applied private international law principles.
Sure, Rajesh, happy to take that up. Aberdeen was, initially it all started at the AAR, and the facts were quite interesting. You had something called the Aberdeen Delaware Business Trust, which was set up in 1996 as a statutory trust under the trust laws of Delaware. And underneath that trust, there were certain other sub-trusts, three of whom are the taxpayers in the Aberdeen series of judgments. Now, these taxpayers had all registered as sub-accounts of an FII and had invested into Indian securities under the FII route in India between 1996 and 2010. In 2010, a decision was taken to convert the main trust, which was the Delaware Statutory Trust, into a limited liability company, a Delaware LLC. The reason behind this was entirely commercial, because the entire funds industry had moved to the LLC regime. The LLC regime allowed fund managers to set up multi-class umbrella fund structures where you could have the benefits of pooling, but assets and liabilities are segregated depending on the investment strategy adopted. So what Aberdeen did was the main trust was converted into an LLC in accordance with both the Trusts Act of Delaware and the LLC Act of Delaware. Now, both laws allowed this conversion to happen. Both laws said that the conversion would be tax neutral. The unit holders in the erstwhile sub-trusts would become shareholders in the current LLCs or the sub-funds rather. And the conversion was entirely tax neutral in the States. The new entity was deemed to be a continuation of the old entity. There was no different entity that was created. The resulting sub-funds or series of the LLC were deemed to be a continuation of the corresponding sub-trusts of the Delaware Statutory Trust. Now, at the time of this conversion, each of these sub-trusts had accumulated losses under the head capital gains over the years. After the conversion happened, the successor entities sought to carry forward those losses. They said that with the same entity as the old entity, So we would like to carry these losses forward, and they approached the authority for advanced rulings, seeking to ask if this carry forward would be allowed, notwithstanding the conversion. So before the AAR, arguments primarily focused on whether the new entity is the same entity, is the same as the old entity. Is there a difference between the two entities? The revenue argued that the new funds are not the same as the subtrust that had incurred the losses. The revenue also argued that the application had been filed by the parent LLC and not by the sub funds that had actually, or the subtrust rather, that had actually incurred the losses. These are some of the arguments that were raised before the AAR. And after examining the law on the issue, specifically the cases on private international law, including TechNIP, the AAR ruled that, look, it's all well and good that you are the same entity under Delaware law. There's no gainsaying that, and we understand that TechNIP respects that provision. But under Section 70 of the Income Tax Act, only the SSC that had incurred the loss could seek carry forward. In this case, the losses were incurred by the three subtrusts who had their own PANs, who had filed their own returns, whereas the application in the present case was filed by the parent LLC. And this parent LLC was never an assessable entity in India. It had never filed any income tax returns in India. It could not have been considered the assessee that incurred the losses that were now sought to be carried forward. So on that basis, the AAR did not allow the carry forward to happen. They said you are different entities, you don't have the same PAN, new entity, and for that reason, they disallowed the losses. And this order was then challenged by the parent LLC and the sub funds before the High Court. Rajesh, anything to add here on the facts or what the AAR said?
Yeah, I think there are a couple of important elements, right? Because in the normal sense of things, we would just think about it and say that, listen, if a trust converts into a LLP, where is there a question of a continuation of the same entity? Because we have provisions in the Income Tax Act which deal with carry forward losses. As a general thumb rule, they do not respect conversion of entities from one entity to another entity, with some exceptions, and definitely not in a situation like what we are talking about, which is a trust converting into a LLC. Under Indian law, an Indian trust cannot even convert into a private limited company or even a partnership. Even that whole concept itself is not recognized. But here you had a situation where you had the US or the Delaware trust law, and you had the Delaware LLC law. And both the Delaware trust law and the Delaware LLC law did allow for a conversion of a trust into a LLC, and also provided that upon such conversion, the entity continues to remain the same. And the question obviously is that under those circumstances, how should Indian law also treat the same issue? Obviously, the way AAR had looked at it was to say that, yes, Indian law will recognize the same entity insofar as the entity is concerned, but when it comes to rights and obligations of the entity, which is how they said, vis-a-vis the tax law, we will only look at Indian law. And that is the basis on which they try to say that, okay, under Indian law, there is no specific provision which is there, which allows for carry forward of losses in terms of conversion of a entity. So this is the backdrop into how at least the AAR sort of thought about it. The arguments of the applicant was actually very simple, which is that the SSE continues to remain the same. It's the same SSE earlier, because that's what, and for that reason you have to look at foreign law on the subject. The second aspect that is also very interesting and important is that in a trust, normally you have a trust, you have a settlor, you have a trustee, and you have beneficiaries. Here we had a situation where there was one trust, and under the trust there were different schemes, and each of the schemes had a different set of beneficiaries. So which is why for trust, for the purposes of when Aberdeen was still a trust, it could file for each of the schemes which had a different set of investors, it had filed or obtained separate PAN numbers and filed separate returns for that. The question obviously was there that when it converted into the LLC, you had the mother LLC and you had effectively a sub LLC which tracked each of the schemes which converted into the LLC. And obviously one of the questions which is also there is that should I look at the LLC as a whole as one SSE, or should I look at each of the sub LLCs also as a separate taxable entity? Importantly enough, under Delaware law and even you could have a situation where even the sub LLCs could have separate existence for all legal purposes, and which is why even though you had multiple sub LLCs which were there, you could still go ahead and say that each one of them should be treated as a separate SSE. Be that as it may, so you ended up in a situation where the AAR said that while we will recognize that the conversion results in a continuation of the entity, but under conflict of laws, do not expect me to assert the rights and obligations under foreign law, but that has to be under Indian law. And absent Indian law provisions, no carry forward laws could be allowed, and which is where the matter went up to the Bombay High Court. And Shipra, I think, why don't you sort of come in terms of how Bombay High Court looked at it, because there were multiple rounds of litigation even before the Bombay High Court.
Sure. So when we first approached the Bombay High Court, like Anandu mentioned, what we did was that in the writ petition, apart from AICFL, which was the mother LLC, we also included the sub-funds of the LLC as petitioners. Having said that, the Bombay High Court did dismiss our petition, but when we went through the judgment, we realized that in terms of principles, the Bombay High Court did agree with us. In the sense that the Bombay High Court accepted the private international law principle that the status of an entity incorporated abroad, so in this case in the US, has to be determined even for Indian law purposes in accordance with the laws of Delaware. Further, since under Delaware law, the mother LLC in its earlier avatar as a trust and post-conversion as an LLC continues to be the same person as per the Trust Act and the Delaware Act, this position has to be accepted in India as well. So therefore, as far as any losses incurred by the mother LLC, the court held that these losses cannot be denied only because of a change in status from trust to the LLC. Having said that, the reason why the Bombay High Court ultimately dismissed our petition was on the grounds that here the losses as such were not incurred by the mother LLC, because the PAN and the tax filings were made by the sub LLCs or the sub trusts. So on this basis and only on this technical reasoning provided by the Bombay High Court, our petition was dismissed and the writ was found to be not maintainable. So moving on to what happened after the first ruling of the Bombay High Court, the tax department initiated reassessment proceedings and against the 3 sub-funds of the LLC. And the reason provided for reinitiating these proceedings was that they had incorrectly carried forward losses incurred by them in their earlier avatar. So because of this reasoning provided by the during the reassessment proceedings, the petitioners again went up to the approach the Bombay High Court seeking to quash the reassessment proceedings. Now at the Bombay High Court, what happened was that the court rejected the tax department's arguments, and the tax department basically argued that as sub-funds of the mother LLC, these sub-funds were distinct and independent from the sub-trust. So this argument was rejected by the Bombay High Court. The Bombay High Court did rely on its previous ruling in the matter of the mother LLC, as well as the Supreme Court's ruling in TechNip, and reiterated that any gain or loss that were incurred by the sub-funds in their earlier avatar as sub-trusts cannot be denied only because of a change of status of the trust into an LLC. So essentially, the court also, took note of the fact that in the previous proceedings, the department had taken the position that only the sub-funds and not the mother LLC would be entitled to carry forward of losses if it is eligible. So the Bombay High Court said, took the stance that since the department has already taken a stance that the sub funds should be should be allowed to carry forward losses if they are so eligible, they cannot now take a different stance. So essentially what the Bombay High Court did was they did quash the reassessment proceedings, and the basis for that was that the sole reason for reopening the assessment was the change in status owing to the conversion. Now, when the Bombay High Court in the first petition has already held that the change in status does not really affect the ability of the trust to carry forward losses, this cannot be a reason for reopening. And accordingly, the Bombay High Court quashed the reassessment proceedings. One other observation made by the Bombay High Court was with respect to alternate legal remedy. So what the court did was that it affirmed the principle in Calcutta discount case of the Supreme Court, which held that if the reassessment proceedings are as such without jurisdiction, then the question of proceeding with an alternate legal remedy doesn't really arise. So this is as far as findings of the Bombay High Court are concerned. Rajesh, your views on how this judgment is going to affect taxpayers in India in future?
Yeah, I think so. So let's look at it. So what the Bombay High Court essentially says is that when it comes to matters in respect of status of a particular person, you will always look to foreign law to determine status. And Anandu, why don't you just go into the next slide in terms of some of the examples, right? So today, when a very often example that comes in, and this is both in the funds industry and also in other cases, is characterization of foreign entities. Usual suspects are how will you treat a Delaware LLC under Indian law? How will you treat a Cayman limited partnership or a Cayman company under Indian law? And even the sort of the more unique ones like protected cell companies or foundations. How would you treat it for Indian law purposes? And a lot of times what I end up seeing is that people end up doing a fact and circumstances test to say that should that entity qualify as a company under Indian law, or should it qualify as a partnership under Indian law. I've also seen cases where sometimes tribunals have not recognized foreign trusts under Indian law for various reasons. But today, I think, and this is where the role of private international law and probably the High Court ruling comes into place, is that you are not required to actually do a comparison analysis or a comparison test in order to determine the status of a entity. For example, if I take a Delaware LLC, US law treats it as a company. US tax law may treat it as a pass-through entity, but that does not mean that the character of the entity changes from corporation to a partnership, which means that India would still have to give recognition to a Delaware LLC as a company under Indian law or as a body corporate. It is important to note that Delaware LLC legislation at nowhere says that it's a body corporate, but considering that US would recognize it as a corporation, Indian law would have to give effect to the same thing. There may be other examples, like for a Cayman exempted partnership. Again, a good reference point would be what I would call the Canaro judgment that came in from the AAR a few years back, which was a case relating to if I recollect right, a Alberta partnership, where the AAR had sort of said that, it's a foreign partnership. Therefore, they went into a fact and circumstances test, said that the foreign partnership has principles broadly similar to an Indian partnership, and therefore we will treat it as a partnership for the purposes of the Indian Income Tax Act. Again, the way I would always approach it is that once Canadian law, Alberta law has recognized that as a partnership, you don't need to do an additional fact and circumstances test to see whether it should be treated again as a partnership for Indian law. the protected cell companies is a more interesting examples, because there we do have a precedent, which was a Nicholas Applegate, as Nishith was pointing out earlier, where and protected cell companies by itself is a very unique creature, because you have, it's effectively like a multi-cell company where each cell has a separate independent existence. So you have different shareholders or members for each one of the cell, and the corporate law of most of the jurisdictions which do have a protected cell company legislation say that that for the under the PCC legislation, each cell will be treated as a separate entity. Nicholas Applegate was a situation where the question before the tribunal in that case, it was the ITAC, was whether you would treat each one of the cells independently, or do you club them all together. The tribunal in that case did take a view that no, I will aggregate it all together. To my mind, if you look at the Aberdeen case, Aberdeen took a different path, said no, that is not the way we will look at it. Even though there are separate schemes or separate subcells, we will still give the recognition which foreign law actually gives in on the issue. Another interesting situation which comes up, which you don't find it too often in India, is the case of a foundation. Foundation is a civil law creature, not a common law creature. You will find it in Liechtenstein, you will find it in a few other European jurisdictions. And questions always come in that how do you treat it under Indian law? Under certain foundation law provisions, it does say that it's a body corporate. And when you see what is an Indian company includes the body corporate, and that's how you sort of derive at the result that they should be treated as a company for Indian tax purposes. But in all of these situations, what is important is that your analysis cannot start with Indian law on the subject. Your analysis always has to start off with the foreign law on the subject. Let me also sort of take a couple of questions which I see in terms of there are questions around saying that if I've set up a foreign trust, should that be treated as a corporation or a trust in India? There is one recent judgment which sort of ignored the fact that a foreign trust should be recognized for Indian laws. To my mind, they went in on an absolute wrong presumption that they did a comparison analysis to say that the partnership law of a foreign jurisdiction does not meet the parameters under Indian Trust Act. To my mind, absolutely wrong approach. Because that's not how conflict of laws work. Similarly, there are a few questions around how would you sort of work on the compliance side, because ultimately, even everything starting from getting a PAN today, the PAN that you get for a trust is not the same as a PAN that you get for a company, obviously. But notwithstanding that, because ultimately procedural law does not determine substantive law. Substantive law actually writes procedural law. So even if there is no specific provision in law, because I will have to get a different PAN between when I was a trust and when I was a LLC, that still does not make a difference. Because if you're treated as the same entity for foreign law purposes, you will continue to be treated as the same entity for Indian law purposes. I think I'll make a couple of closing comments before Nishith, I will take it to you. One is that while this was a lot on the substantive law, but even as I said earlier, on situations such as summons or on situations such as recovery, you will have to. There are places where you will have to look at the foreign laws on the subject rather than the Indian law. A good example would be that today, Indian law allows for director's liability. The Indian tax law allows for director's liability under certain situations. Foreign law may not necessarily allow for it. So in case of a foreign company, if the foreign law says that directors are not going to be liable under any circumstances, can Indian tax law then say that, oh, you know what, we are still going to initiate proceedings against the directors, or we are going to, can directors be held liable? The answer to that is that you will have to look into foreign law foreign law will not enforce any judgment which is passed by Indian law on the subject. They will say that, listen, if the foreign law does not allow for director's liability, you cannot then impose a liability under Indian law. So that's, I think, some of the kind of issues which does come in. So Nishith, why don't I take it to you in terms of any other additional thoughts? And in the meantime, we'll see whether there are any other questions that we need to address.
Yeah, I think there are lots of questions that have come up, and I think some I think we'll take them up offline and send them some replies as well. But it seems that the whole area of private international law vis-a-vis national tax has remained very unexplored, and there are a number of situations, and particularly now that India will also be seeing lot many more cross-border restructurings, cross-border issues in relation to personal wealth and succession, family issues. This subject is becoming very important. That was the essence of today's conversation, and it will also bring out a lot of creativity, and particularly private national law has significantly evolved in the US and Europe, because in the US, like for example, every state is like a country. We call it United States of America, but in lighter vein, if I may say so, it's most un-United States of America, and each state is like a country. And so the interaction or interplay between different states and transactions gives rise to a lot many more international private national law issues. Same way in Europe, the countries are so small that constantly there is interaction, and therefore we have to really, see how the interplay happens, and add to that international tax again. That has another degree of complications, and so I think at the moment I would like not to extend too much. I think we are just coming to the end of the session, and there's some questions which have come. I will send them our reactions in separately, because it will take time to get into those questions at this point in time.
Yeah. So Nishith, sorry, before we wind up, I do want to take a couple of interesting questions which have come up, which
Yeah.
I think one of the questions that has come in is that, does municipal law have the power to recharacterize the nature of business vehicle defined under foreign law, or is it valid? To my mind, the answer is no, municipal law does not have the power to recharacterize the nature of a business vehicle, which is precisely, I think, dovetails into the issue of lex domicile. Which means that can I essentially say that I will treat a foreign partnership as a company for Indian law purposes? The answer is that, as a general thumb rule, no, you should not be doing that.
Rajesh, you may want to clarify that when you say municipal law is local,
Yeah,
it's not
municipal law.
municipality
Okay,
law.
yeah. When we talk
Of
about
course.
municipal law, we are talking about the country in which the tax laws are there. And when we are talking about foreign law, it talks about the country where the entity is registered or incorporated. So when we talk about municipal law, can India today say that I will not recognize a foreign company? I will recognize it as a partnership, for example. The answer to that is no, because as a thumb rule, India has to follow the foreign law on the subject and not the local Indian law. Similarly, I see some questions around private international law principles and foreign mergers and acquisitions. Here again, we've had situations in the past. I think you did have an AAR case in Citicorp, which sort of said that if the foreign law has considered a particular transaction as a tax neutral transaction under where the principles of 47 are met, Indian law will also follow that. So today, for example, if a particular company recognizes a merger or amalgamation in a slightly different manner, right? Indian law will have to go in under the same premise, because ultimately the question of a merger or amalgamation under foreign law is not an Indian law issue. It is a foreign law issue, and so long as you have met with the test under foreign law, that's what you would actually follow to see whether it was a merger or amalgamation. Some of these principles are actually very useful and important when we look at restructuring transactions in terms of how you sort of build in the relationship between the two. I will take the last question, which was a conversion of, let's say, a Massachusetts trust to a Delaware trust, or a Maryland corporation to a Delaware trust, and how those kind of situations would be treated. The way that you would look at it, for example, Delaware trust law or Delaware LLC law today does allow for even a trust or a LLC set up in a different jurisdiction to reincorporate or become a Delaware trust or a Delaware LLC, and they also recognize it as the same entity continuing, which again is how Indian law will also have to follow that. So, which means that if a Massachusetts trust today converts into a Delaware trust, it's still the same entity that continues. In inter-country situation or cross-border situations, we see a lot in terms of reincorporation, because there are certain legislations or certain countries which allow for reincorporation, which means that today, if you're incorporated in country A, you have the ability to change your seat and become and reincorporate in country B. And country B will say that I will treat you as a continuation of the entity in country A, and I will not treat it as a case of dissolution and new entity being set up. So long as that is the case, India would also have to give recognition to it, to say that it is a continuation of the same entity and it is not a creation of a fresh entity. So that is something which
Rajesh, you are right. You are right. I think, and this issue of corporate migration constantly comes up. And the typical principle is that you can export. There are two expressions used: the exporting country and importing country. So corporations, when they migrate from, say, Mauritius to Delaware or somewhere else, or Delaware to Mauritius, now if you, both countries normally should provide that if Delaware company moves to Mauritius, then Mauritius law should say that it Delaware company would not be deemed to have been liquidated, because once if it is liquidated, then your Indian consequences, at times if it is an asset in India. And similarly, Delaware corporation also, or Delaware corporate law also should allow that companies can be exported to Mauritius. So both countries, when they provide export and import of the companies, then you can effectively have a migration without much consequence. And those will be generally respected when it comes to India. So those are kind of things that we'll have to bear in mind. So it is very like individual migration. Corporate migration is not uncommon globally, and it constantly happens. And even within the US, as I said, from California to Delaware, or from, as I said, Delaware to Mauritius or Singapore or other places. Of course, Singapore has a restriction on importation of companies and exportation as well. There are certain situations to that, but many countries do allow, and we have to look into all the countries, the way in which the laws are applied, and work around that. Go ahead. Sorry for my interruption.
Yeah, no worries, Nishith. And I'll take up my last question from Himanshu on the question as to whether the revenue took a stance that the foreign statutory trust would be an association of persons, and by allowing carry forward of loss, a non-resident is treated in a better manner than an Indian resident, because an Indian association of persons may not be generally be allowed for that. The answer to that is that yes, the revenue did raise that argument, but in a slightly different form. What they really argued was that listen, the Income Tax Act only allows for certain kinds of conversion under which a carry forward of loss is allowed. A situation where a trust converts into a company cannot be a situation where a benefit of carry forward of loss is allowed. That is not something that is allowed under the chapter on carry forward of losses. They did not argue on the issue that a non-resident is being treated better than an Indian resident, because there is no such specific provision. Because even when we look at our non-discrimination provisions in tax treaties, right, it's always the other way around, that you cannot treat a foreign person in a worse off situation. So while that point was not argued, but the point saying that a conversion Indian tax resident in a similar situation will not get the benefit, that was argued in a slightly different form. I think there are a lot of other questions, but I know we've sort of run over time, so I'm not will try to answer that separately. But thanks a lot for joining in. Nishith, any final thoughts before we wind up?
No, I think we have crossed our time quite a bit, but one thing that, all our recordings would be available on Nishith mobile app after a week, or, just about a week it takes to, get this thing. Secondly, also, and some of you might be interested, the participants, in outbound investment into Vietnam, Cambodia, Bangladesh, and Myanmar, because as you all know, after the COVID situation, there is the global supply chain from China has broken, and there has been a lot of talk on migrating Chinese manufacturing facilities to India. But as far as India is concerned, it is not an easy environment to immediately bring them to our country. And so, what do you do in the interim? When we talk to the major consulting firms, their view is that if there are 100 companies likely to migrate from China, about 50 will go back to the US if it is from the US originated. Because US had remaining 50, 30, 40, 50 companies, about 30, 40 will still go to some of these South Asian countries. And India, for manufacturing, has opportunity for about 10% of the Chinese companies. Little unfortunate though, but that is what we have heard. Now, what do you do in this situation? Because India will take 2-3 years by the time our manufacturing, regulatory, and tax practice, other things will still take some time to, evolve. So, in the interim, one of the strategies we are looking at is that can you migrate these companies from China? Indian companies can buy, move them to Vietnam, Cambodia, and some other jurisdictions, and then over a period of time you bring them to India, or you operate from there. I think it's still not bad because India can provide technology, services, management, expertise, and a lot of other things. So it's still a win-win situation, but you don't miss out on opportunity on migrating Chinese company to outside China. And it would be useful if some of you are interested in hearing the conversation on that. Next week, I think we have 2 days on Wednesday and Friday doing business in these jurisdictions like Vietnam. Vietnam is doing extremely well at this point in time. Cambodia, Myanmar, Bangladesh, and so on and so forth. So, welcome, and we try to see if we can share whatever little knowledge we have and experience. It's always a pleasure, and do stay connected. Wonderful to have you with us this afternoon. So thank you so much.